Okay? So the first thing is to convert the court from equity to law, and you do that with a proper pleading, which in a criminal case is an acceptance of all the facts, additional facts put in by affidavit, which changes the presumptions of law. Then the next thing we got to do is turn the magistrate from an administrator into a judicial officer, and we now know how to do that by contracting privately with him to put his oath of office into the proceedings. Now the last thing we have to do is we have to convert the counselors from equity to law. And again, in order to convert the counselors from equity to law, you've got to change the counselors from the presumption that they're going to argue facts for you, the defendant, on the public side, into an agreement that the counselors will try to settle and close the matter by putting the contracts in front of the court and the breach of contract, and request the judge take mandatory judicial notice of the contract, the breach, and the necessity to notice that to get an execution in law. Now we've changed all three equitable elements of the proceedings into law. Now we can move forward. There is, in the movie that I talked about last week, The Italian Job, remember there was a conversation going on with two of the principal thieves in there, Donald Sutherland, the elder one that was retiring, being the one. And he said it is not about theft to get wealthy, but about theft to define who you are. Now remember, all commerce is theft because it's all fraud, it's all fiction. Because there's no money anymore, how can you carry on commerce without money? All you have is the illusion of a substitute for money, so all commerce is a fiction. So therefore, all commerce is a fraud. And he says you do not deal in theft or fraud to get wealthy, but define who you are. What is it that the judges and the lawyers are doing? In the courts, aren't they using fraud, deceit, theft, all these good things? What is their purpose? To test you. Are you in it for the wealth, or are you in it to define who you are? Think about this again, Lee, from the conversation we just had up there at the mic with you about 10 minutes ago. Remember I said maybe what this guy has to do is this guy has to, in some way, shape, and form, agree to go the distance, agree to go to Timbuktu to get his kids, because they mean that much to him. Not because he shouldn't have them brought to him under the agreement. Yeah, but is this guy in it for the wealth? Does he want to possess the children? Or is he in it to define who he is? Is he willing to go to Timbuktu to get his kids? Because his kids are that important to him. Versus, well, I'll take my kids if she drives them from Timbuktu to me. But is that just possessions? Is that just, well, look, I've got my kids now. They're another prize hanging up on my closet wall. I get the kids, she doesn't get the kids. See, the whole concept is it defining who you are? Now, when the judge comes in and the lawyers come in, and they do all of these, what the patriots are obviously going to call fraudulent, deceiving things. They have no right to do that. The public's bankrupt. You can't execute anything. They just want to come in and give you a bad time. There is a reason that the government, the lawyers, the judges, the attorneys were empowered to do this by the Creator. They were empowered to do that because the Creator believes His people don't care about the law and care about important things anymore. All they want to have is the easy life and have the easy way. Just do what I want. It's all about me. It's not about doing His will. So consequently, are these people, the government, the lawyers, the bankers, are they empowered to use commerce, which is a fraud, to charge you, to test, to define who you are in the eyes of the Father? Are they His agents to define you, or to refine you, or to take the dross out of you? And are you rebelling against them because, as far as you're concerned, it has nothing to do with me defining my relationship with the Father? Everybody knows I'm the good guy. I'm deserving. The Father wants me to have everything I deserve, and you guys won't give it to me. Is that more about the wealth that you think you want and deserve, or is it about using the events of this life to test you, to define who you are? We know everything they're doing is fraud and theft. But isn't that everything we've been doing too, as the principals? And they're just the shadows. And the point is if we can use that and not complain about it, not fight it, not try to destroy the testers, but to understand that we are the tested, and it's about perfecting us, not bringing down the testers, then maybe we can just go in there with the right attitude and get things done correctly. Now, there is a case going on up here in another state where 3 people involved, 2 of my friends and a public notary. And the public notary and my 2 friends have been charged with racketeering, corrupt practices, conspiracies, the whole bit. It started out about some properties and some property taxes. So it deals with the counties. And with the property and with the taxes, my friend is going, well, you know, I'm registering all these properties on the UCC and I don't owe no stinking taxes. And so right away, if you've got the attitude that you don't owe no stinking taxes, you're in a warfare with all the taxing authorities. Now, I don't care whether the tax is property, income, excise, you name it. It's immaterial and it's irrelevant. We've talked about that so many times. Just go back to Matthew 17. Do you owe the taxes? The answer is absolutely not. You don't owe 1 penny of those taxes. Matthew 17. Should you pay the taxes anyway? Absolutely. I didn't say with what. That wasn't the issue. Pay the taxes lest you're in a dishonor. At no time did the Messiah ever get in trouble with the taxing authorities or with Rome. Never. He never had a speeding ticket. He was only in trouble with the domestic church head. He was in trouble with his own family. He was never, ever in trouble with Rome. So the federal government is Rome. It's not the de jure government of your state. Why are you in trouble with those people? And your local state is in a co-business relationship with Rome, as are your local municipalities. Never in trouble with those people either. Show me one time in the Scripture he was in trouble. He preached to the people that were trespassing on the church once, but he threw them out. He certainly didn't go to public authorities and bring charges. So the answer to taxes is you don't owe them, and the other answer to taxes is if they ask, pay them. And we're not going to get into how and what. That's just the answers to the riddle at far. Now, he wasn't paying some taxes. He was using some administrative process and everything else. So the locals did the following. They never got involved in an argument with any of this process. They just up one day and said, well, that's it. We're foreclosing for a tax sale on the property. They put it up for bid and they sold it to third parties. I'll call those parties the B parties. Bought these properties, paid the taxes. The A party is going to be my two friends. One that owns some of the property, and my other friend got involved by a contract and said, now I own them, and therefore I'm going to deal with them. And the B parties then went, or the A parties, the people that were fighting the taxes, went to the B parties, the ones that bought the property, and they basically started an administrative process with the B party people that thought they bought the properties in order to resolve the issue of who had the best title on these properties. Everybody in the picture, or have I confused you? So A people said, well, you know, I tendered the exemption and everything, and the public didn't go for it, but they're discharged and we own them and whatever. And the B parties go, no, we bought them at a tax sale and they're our properties and we're going to sell them. So the A people started an administrative process against the B people, and the B people never responded to the administrative process. So as time went by, the A people got a certificate of protest, one in many, against the B people, informed the B people that they were in dishonor by way of a certificate of protest, and the A people filed the properties as security interests on the UCC-1s in the state, claiming that the A people had a secured party creditor interest in a finance statement over the B people with regard to these properties. Now, so far, do you think there's anything wrong? Well, wait a minute. So far, there's nothing wrong. The B people dishonored and failed to respond. And assuming that all the process was with notice and everything else, we've got basically an administrative judgment that's registered on a UCC-1. Cool. Now, the B people decided that they'd had it and they went to see some attorneys. So the attorneys filed a court action for quiet title on all the properties in a state court. And they summoned the A people as the offenders to come into the case. What did the A people do? The A people, basically being patriots, said, we got our private judgments. We're not going to give jurisdiction to the public courts to screw this up. We've already got the case decided. Screw you guys. They dishonored the court. To which the attorneys for the B parties filed a motion for default judgment and were granted default judgment. So now this is the way the property tax wars are going. In this particular state, you have filings in the Secretary of State's office saying that parties A have a superior interest in these lands. And in a circuit court in this state, which is a public tribunal, you have a court judgment saying that parties B have a superior interest in the same land over party A. Do you think that the public records of this state have a problem? Absolutely. What's the problem? They don't concur. So obviously, one is wrong, the other is right, or both are wrong. However, this state has a vested interest through its public officials and trustees not to maintain fraudulent records, records which show the opposite thing. That'll just be way too confusing for the public. So needless to say, what they needed to do was, in equity, have a third court case that would break the tie. After all, in equity, it's just looking at weights and measures, right? And what is weights and measures except fraud? Isn't every measurement a presumption? It's not real. That's why you have weights and measures, to take it to an illusion. Because the measurement of the thing is not the thing. It's somebody's opinion about the thing, which is therefore merely a fabrication or an illusion. Some illusions might be more accurate than others, but every weights and measure is an illusion. It's equitable. So, since we're looking at a balance on the scales of justice and equity, right now we've got A rules, B rules, and the scale is even in this state. And obviously the public has to have an opinion, so we have to tip that scale. So let's start a third case. And whichever way that case comes out, it'll go on one side or the other. And in equity, we will know for sure in fraudulent equity exactly what we're going to believe as a presumption. Now, doesn't that make absolute sense to you? So the case they elected was a criminal case against Party A. We'll charge Party A with creating false records. Now, can they take a finance statement out of a UCC? Not unless it's a fraud and a result of a criminal action. But if it's fraud and the result of a criminal action, then by the jury or the confession of the party with the fraud, it can be absolved, because you can't have the fruits of crime cluttering up the records of the state. So ordinarily, since a finance statement is a contract in the agreement of the parties, and the public cannot intercede, the only way they could get that UCC out of there is if they convict the people in Party A of a crime in having put it there in the first place. You see what they're trying to do? Now, why is Party A charged with a crime? It has nothing to do with taxes. They didn't show up for court. This isn't about taxes. This isn't even about who has title of the property. Does the state care who has title of the property? Hell no. It's irrelevant. Does the state care whether the administrative procedure of Party A is valid? No. It's about a contempt for not showing up in court. That's what this is about. And the one guy is on a $1 million cash bond. You don't think they don't treat contempt seriously? Could go to jail probably for 30 or more years. You don't think they don't treat contempt seriously? Listen very carefully. Party A honored Party B and threw at him an offer. Did Party B respond honorably to the offer? No. What was the penalty for them having not responded? There was a finance statement registered on the UCC that basically said their interest in the land was inferior to Party A. Is that why Party A is being charged in the criminal case? No. Listen carefully. The state comes back and its interest is we've got to make sure our records are accurate, and they're totally screwed up now. Because Party A never came in with their claim into the court. If they had a claim, why didn't they show up? Well, when they didn't show up, the court assumed and presumed they didn't have a claim. Otherwise, what stupid idiots with a claim wouldn't bring their claim? Which leads credence to the belief that these people are a bunch of fraud imposters. Now, when the state said kindly to them, "Oh, would you please come into this court and produce your claim?" And they go, "Screw you, we're not going to respond." What did Party A do to Party B for the same thing? Based on the dishonor, they got put into contempt. When what's good for the goose is good for the gander, when Party A didn't show up to Party B's solicitation, what did they do to Party A? They are bringing them into a criminal proceedings. If you don't think this administrative process isn't valid, wasn't the public court's proceedings exactly the mirror image of their proceedings from A to B? And they treated B really nasty when they didn't come in and said, "Okay, you lost your interest." What did you expect the state to do to Party A when they didn't come in and respond to the state trying to resolve this issue? I said, "What's the matter with you lunatics? You guys are going to, are you in it to define who you are, or are you in it to get the wealth of that property? You want to use the procedure, and if they dishonor you, we'll take the wealth of that property." But then the state comes in and says, "Well, very good, you did a private administrative process. In order to perfect that, you ought to bring it into the public." Now, instead of them filing it in the public, B came in and filed it in the public. Better yet, because B is the debtors. Well, dang, weren't they the debtors because of the process that they used? So the debtors went low and humbly came into the court with their tails dragging, going, "I don't know, could you give us a clear title to this land, please?" And so they went out and said, "Okay, all you creditors A, come on in and bring your claim and get a second witness on the public side." And these people go, "Nope, I'm not going to let you witness for me. This is my claim, and I'm not going to give it to the public. Thank you very much." Beep. You lose. Now, here are these guys sitting in jail, Party A. And Party A goes, "I think what we're going to do is bring a tort claim action against the judge and the prosecutor." Wait a minute. Why are you here to begin with? Is it the judge's and the prosecutor's fault that you've been brought into a criminal proceedings, or is this of your own making by your own dishonor? You see what's going on? We don't need lawyers and the public dissing the commercial process. We are all idiots. We'll screw it up ourselves, thank you. We'll just go out and be totally inconsistent. We'll take an absolutely A++ procedure and we'll use it only for ourselves and allow nobody else to use it. And then we wonder why it is that these people are going to jail. Now, there is a, quote, patriot lawyer, which is really an oxymoron, and I will mention no names. And if you go to his website, he will tell you flat off that Elvick, Smith, and anybody else that's teaching commercial process are a bunch of idiots. And everybody that listens is going to jail. And we don't need this. We got to get rid of these so-called guru, patriot, idiot, lunatics that are teaching all this false crap. The problem is, it's the only remedy, and he knows that. I won't get involved in any discussions, any arguments, and any defenses with these patriot, lawyer, oxymoron types. All they're interested in doing is proceeding in equity. What is the world of equity? Fiction, assumption, and presumption. These lawyers can charge Elvick with anything they want in equity because it's all an illusion and all in fiction. And I talked with a couple of people this week, and they said, oh, we actually contacted this guy, and we had some discussions with this guy. And after about the second or third response, he just said, well, we disagree, and went away. He said, obviously, this guy doesn't know what he's talking about, or better yet, he does, and he has no logical explanation for where the rubber meets the road. All he's trying to do is deceive people and get more contacts and clients for himself. And I said, why are you arguing with these people? They're an illusion. You can't argue these things. If you look at this guy's internet website, every fact he has on there about Elvick and me, the facts he put there are true. His facts, as he states them with his conclusions, are true. Of course, they don't bear any resemblance to the facts that Elvick and I are actually teaching. But if you believe that his rendition of our facts are what we say, then everything he's saying is absolutely true. There's no sense arguing with somebody in equity. There's no reality. The reality, though, is, my friends, Party A perceived and assumed that once they got the private administrative procedure done and filed it on the UCC, they were king and that was it. They failed to understand it takes a double witness. Why does it take a double witness? Well, in Scripture it does. Romans 13, why are you afraid of the king? If you're doing that which is good, he'll rubber stamp what you're doing. What did we talk about King Henry II? 1178. You people don't have the capacity to resolve your matter privately without the king's consent, i.e., without the public witness. Do you think that came in for a first time in 1178 AD? Think that's the first time that ever happened? Got an example of an earlier case? Genesis 23. What was in Genesis 23? Is that where Abram was negotiating the sale of the cemetery plot for Sarah? Did he negotiate it in private or public or both? Both. He got the seller of the land to agree to sell it. They settled the price, and they did it in the center of the town square for the whole community. Or the newspaper, either one. You can't do this only privately. Not in this world. It's a mixture of both equity and law. And you've got to have the law private decision, and you've got to take it to the equity court. You can attempt to turn the court of equity into law, but it'll never acknowledge it's in law. It will always have the trappings of equity, but it will give you the witness as though it were in law, notwithstanding if you've done it right. Joe, you got a comment?
Yes, I seem to pick up a difference between this little dissertation about going before the public to, and that's where I'm going to draw the question mark. Originally, I thought you were saying that we could not resolve a conflict privately and that we must go to the public to resolve it.
Actually, you're going to resolve it privately. Then you're going to go to the public, and the public is going to second witness it. And the reason you got to get the public to second witness it is because if you're in law, you're outside that government.
Okay,
so you're foreign to them. Hang on a second, then I'll let you have a turn again. If you're doing it privately, you're foreign to that government, you're outside. But parties B in this case are citizens, residents, fictions of the equity. And they're subjects of that public government. And you can't execute against their subjects without the permission of their masters, which is why you have to take your private judgment before their government in public, basically to get their government to tell them, you're going to listen to this guy over here and he's got the title. Does that make sense?
That makes sense, but that sounds...
Pardon?
Notary protest?
The notary protest is the end of the private portion, not the beginning and end of the public portion. Go ahead, Joe.
That sounds different than what you just now said about making a private agreement and then having the government through the newspaper or through speaking in a public square being given notice. Being given notice and having them make a decision to bless your agreement is two different things.
The only reason you're in the court is because there's another party that's brought an action protesting. Ordinarily, if you're just giving public notice, like, look at it this way. If that private process culminated in the UCC1 and nobody ever brought that action any farther, is that a fulfillment of all we need?
I want to say yes, but...
Yeah, there's nobody objecting, protesting, or complaining.
Well, then
evidently, we're going to law in this meeting because Caleb just threw the clock out, and time is a fiction. So we're in good shape. We're back in law now. Is that saying, Caleb, that your attempt to resurrect the clock in this facility went down in flames? It was a waste of time. Okay. Oh. That's what you get for trying to bring fictions into our meeting, like time. Change the battle.
So what was the resolution here? I'm saying that there's a difference between giving the government the public notice and there's a difference between asking the government's approval of private transaction.
Okay. Isn't UCC1 giving notice? That's exactly what it is. You're giving public notice. Okay? Now, once Party A gave public notice, what did Party B do?
Either agree to send it to it.
Party B didn't like the notice, did they? So what did Party B do? Filed an action in their equitable tribunal to get the notice that Party A placed in the public records set aside by a new agreement of the parties.
Right, well, now we're talking about a conflict. I wasn't talking about a conflict. I was talking about where two parties are in agreement, and you said you can't make that agreement until they go to the public. That's the issue. There are two parties.
No, they could make any agreement in the private they want.
I guess the issue is, I don't understand, is...
The judge, or Henry II, didn't say you couldn't write a private contract, did he? In his Curia Regis, the Act of 1178 A.D., he did not prohibit private contracts. Did he? No, which is a private agreement of the parties. He can't do that. Everything in commerce moves on contract. He can't outlaw contract. What does it say in the Bill of Limitations in the United States Constitution?
Make no act or affecting the contract.
They can't affect a contract. Okay? Now, when that got into the Bill of Limitations of the Constitution, can't affect the contract, King Henry didn't say you can't affect the contract. He said you can't resolve a dispute privately. You can't resolve a dispute privately on the contract. He didn't say you couldn't write a contract. Now, the UCC filing is public notice of an alleged agreed-upon contract.
Notice.
It's notice of an alleged agreed-upon contract.
Okay. No, the issue I'm making is notice is different than getting the public's approval.
Correct. If there is dispute as a result of the notice, it's public, and that cannot be resolved privately.
Okay, so you're saying only in cases of dispute do you have to go to the public?
You can, well, New Testament says try to resolve it before you get from the judge. Fine, let's try to resolve it before we get to the judge. Are you going to try to resolve it privately?
Yes.
You bet. However, even if you resolve it, what do you got to do? Go to the judge and say, we resolved it, this is what we've agreed to, and the judge will say, fine, then does the plaintiff want to dismiss, or does the offender want to accept and agree? There's going to be a public dissolution or some kind of solution to that disagreement, even if the parties attempt to resolve it privately before they get there. Now, what Lee was telling us about with this gentleman and his ex-wife before is they had disagreements. There was even contracts. But the court came back and said, okay, so there was a contract, then there was a violation. Won't you please go out and try to resolve it? The court's saying, please try to resolve your differences. But is the court saying, we don't want you to come back here, we don't want to hear this thing anymore? No, if you try to resolve it, coming back to us so that we can give a public blessing on your solution. So what happened is when the attorneys for Party B filed a case, a charging instrument in the court, it became a dispute. And that dispute had to be settled publicly. The dispute ultimately could not be settled privately without the public's blessing. That's what we're saying. But had Party B never hired lawyers and never went into the court, where would we be today? Presumptively and assumptively under equity, Party B has agreed to what Party A put into the record. There is no dispute, i.e., there is no problem. Is this case deal with taxation of property? No. Does it deal with the administrative process as far as A took it against B? No. They said, in equity, all scales having equal thing, if A can do this against B, and if B screws up, and they dishonor and bonk, there's a penalty, then let's test A and do the same thing with A. And if A dishonors, dang, they're going to get a penalty too, because they applied a penalty to B. What's good for them is good for us to do to them. We're using their same standard of justice. See, the whole problem, the reason these people are under felony charges, is because they're not consistent in their commercial private process. They want to use it for their advantage. They don't want to allow the other side to use it. Can't do that.
As far as the notice being public notice, actually two things. The first part of the notice, wouldn't it have been to put in the paper under public notice that they have a filing with this particular property, just like when they do a tax sale or something, it's put in the newspaper, property so-and-so, case number, this, that, and the other, location and description. The other question that I have...
Why is that relevant right now? Are you saying the UCC one wasn't sufficient notice, or they should have done something else? Why? This problem is not about the type of notice they gave. This problem was about equal protection of law. What you did to them, we could do to you. You allow it to be done to them, but you won't allow it to be done to you. There's no equal protection. There's no due process of law here.
Okay, my second question is, not really ready for this, but difference between the notice, like a public notice type, and something that I received when I purchased a product, and inside it had a declaration of something on there, and it had a few words that it meets the standards of CFR, whatever codified for that particular product. Now, what is a declaration when they have that? Is that something like a notice, public notice, or?
Well, a declaration, was it going to be under oath? Is it going to have true facts in it?
The declaration stated, declaration of product consistency under CFR of so-and-so on the rules of...
All they're doing is certifying a compliance with a statute or a regulation. It's a certification, which stands as a presumption for compliance until rebutted. Many times, in order to get paid on commercial contracts, the seller or the manufacturer has to put out certificates of compliance to meet certain standards in order to induce the financier or the bank to release payments for goods so that we know they meet certain requirements and are not going to be a liability to the buyer.
I've seen certificate of, what they say certificate, but I've never seen a declaration before in a product.
Well, certificate is what's usually put out by maritime insurance, and a declaration is something that usually deals in law. But it's just one law form over the other. In law, you usually don't need insurances per se because it's buyer beware. The transaction doesn't take place through third parties. It takes place directly between the buyer and the seller, and there usually is no insurance in certifications.
Is the notice then a legal form?
It's a form to tell the public a relationship which exists to which the public needs to witness or understand in order to keep the parties in compliance with their agreement. The public is the surety for the parties making the contract. That's why the judge in law stands for the people.
So declaration is on the law side.
Yep.
More. Okay.
Okay. So what we see going on in this particular case is we got these people being charged, parties A. Now, remember there were three parties charged. There was a public notary and the two principals. Now, theoretically, they're charged with some kind of a racketeering, corrupt, influenced enterprise that's out there for the purpose of bribing the people in Party B to turn over money in order that the titles on the lands would not be clouded, creating a commercial liability against their property interest. In other words, well, pay us a bunch of money and we'll uncloud your title and you can get your property rights. So supposedly Party A is in a racketeering, corrupt, influenced organization for the purpose of going around under fraud, clouding titles to land in order to extort bribery money or pay off money from Party B so that they can clear their titles and sell their lands and get a profit. So it's an extortion racket industry, presumably. Now, when it came to the notary public, whose only job it was to witness signatures and to create certificate of protest in the private administrative procedure, why was he brought in? What is the state presumably trying to do with this criminal case? Isn't the state in this criminal case trying to either dissolve the quiet title court action or the UCC-1 filings? So what they're doing by presumption, who was the last party to dishonor, A or B? A. So the presumption goes against party A. And so the documents in favor of party A are the UCC filings in the Secretary of State's office. So the purpose of this criminal case is to resolve a commercial conflict in the records of the state. And what they need to have is a lawful and legal reason to dissolve the UCC-1 filings. So what was the presumption that the UCC-1 filings were and were used for? It's a presumption that they are a fraud used for extortion, and they're not real. So then everybody allegedly that touched the creation of those instruments are party to the racketeering, corrupt, fraudulent proceedings. Doesn't that make logical sense? And so they said, well, gee, what part did the guy have who was a notary public? Well, maybe he was using his license for his buddy's goal of just creating this racketeering, influence, corrupt practices thing, and he's getting cut in on the money. Is it possible that that could be true? Yeah, it's possible it could be true. That doesn't mean it is true. It's just possible it could be true. So can they presume to have to charge him? Let the record show that the timepiece is back and the little hand is moving.
Not for long, though. It will stick again.
Caleb has not stabbed it with his knife yet. That's a good sign, maybe. So they brought the public notary in on the presumption maybe he was just working with his buddies. Now remember, the facts in the charging instrument, we read them a week or so ago, all it had was dates, cities, and names of people that are in Party B in it. Are those facts all true? Yeah. So those facts are law. They're all true. But then they immediately jump to the conclusion that the public notary was racketeering and bribing Party B. But there were no facts in the charging instrument that alleged that. Now, what our hero, the public notary, does is he comes in and pleads guilty to the facts, which means I don't want to argue the law side of this case, which is true. Then he put in an affidavit where he denied being a member of a gang, denied being involved in anything for the money, denied sharing any loot with anybody for anything, denied even having knowledge that that was an intent. Then he came back forth and he said, and isn't it true that if somebody comes in and swears, puts their hand up, and I know nothing beyond that, that I've got to notarize their document as part of my job? And isn't it true if they bring in documents which are evidences of dishonor, I have to do a certificate of protest as my duty pursuant to the workbook for public notaries? Further affiant saith not. Has he just introduced facts now to rebut the presumptions of law in the charging instrument? Yes. So now he says, I want this case to be law, and I want you to take a look at the contracts, find out who's involved in the breach, and rule accordingly, and I'm just a lowly public notary. I have no interest in the lands, never did have, don't, won't have. Now, what should that do as far as he is concerned in this matter? Should take him back, or at least it puts the ball back into the court on the other side to come forth and rebut those presumptions and prove reality, not just assumptions and presumptions. Okay? Now, what's interesting is this guy went into the court. The first time I think I told you, he gave the letter rogatory, i.e. what he wanted the court to do, to the attorney. At the bottom it says, I've sent copies to the prosecutor, the clerk, and the judge of the private letter rogatory of instructions. I've given you, my public defender, a blue ink original affidavit of negative averment. I want you to file it in the court on the public side. And he was supposed to, i.e. our public notary, was supposed to have sent copies of all this himself privately to the judge, the clerk, and the prosecutor to know what's going on. Now, he didn't understand what he was doing, so he took all the letters and all the affidavits to the lawyer. And I told you the lawyer, this was right before the hearing, 5 minutes before the hearing. So his lawyer, whatever he came in there thinking he was going to do, all of a sudden got hit by the letter rogatory and the affidavit. He saw the affidavit first. He says, boy, this is great. Let me have this. We can use this. He didn't say he was going to put it in the court, although that's what he was told to do. Then he looked at the letter rogatory and he said, this is the most incredible, concise explanation of this process I've ever seen. And that's when the public notary said, well, I don't really understand what I just gave you. So the attorney looked at him and said, well, if this goes wrong, I may need a bond myself, because in the letter rogatory, he asked the attorney to make sure the judge gives him an OR bond so that he could own the case and plead to it. But then the attorney says, I'll tell you what, you got to separate yourself from the other defendants. And he implied that this guy shouldn't use this, quote, patriot-like pleading material, because it'll really get the judge angry if you do this. So he gave him back all the letters and said, if I were you, I'd tear these up. So then the attorney goes into a hearing, which turns out not to be a hearing, because when he comes out, he says, we didn't do anything. Yeah, right. What they didn't do while they weren't doing anything is the attorney probably showed the judge the affidavit and said, and by the way, I got a letter rogatory and he wants to mail one to all of you. What are we going to do about that? And the judge says, well, he took it back. Yep. You don't have it. Yep. Okay, we'll just postpone this hearing and hold it next week. And in the meantime, we're going to relieve you of your job, and there's going to be a substitute for you, so you won't be liable anymore for not doing what you were told to do. So sure enough, the attorney didn't tell the public notary that day he wasn't going to be there next week. He just said, well, the hearing's moved to next week. And then the next day, the attorney calls him up and says, by the way, I can't be there. I got a conflict. I just checked my schedule. Oh, boy, am I busy at that time, so you're going to get a different attorney. Good luck. Now, the public notary says, geez, what's that all about? And I go, ain't it obvious? He doesn't want to be liable for not doing officially what you told him to do, so they're going to bring in another ringer. I said, if you're going to do this process and do it right, start all over again. You're going to have to send a letter rogatory now to the new attorney and tell the new attorney to do what you told the old attorney to do. You're going to have to get a new original affidavit and send that to her and tell her to put it in. This time, don't give her all the letters. Send them privately by certified mailing or certificate of mailing so you can prove that they had notice. So he went to the hearing last week, which is the hearing after the first one, and he got there. And again, they held a hearing that didn't seem to be much of a hearing and do anything. Duh, I wonder why. And then he keeps saying, this is really weird. He says, my attorney keeps saying, I'm not going to put this in the court record unless the judge says it's okay. Good attorney. Knows exactly how to operate on the public side within his equitable bar card. So I said, okay, that's interesting because the judge, the prosecutor, everybody got copies of this, but your attorney said I'm not going to do it. Did he file it? Nope. Check the record. He didn't file it. I go, better yet, there's your dishonor. So I said, everything is right on course. And he goes, what do you mean it's on course? It's not in there and he's not doing it. I said, well, no, you don't understand. It's all backwards. If he was doing it, if it was in there, I'd probably start getting worried. Chances are it's all backwards. It's not in there. I said, what's going on now? Well, when we went to this hearing, there really wasn't a hearing. The only thing they did is they came out to the three of us and they said, we'd like to make you an offer. And I go, cool, what was the offer? I said, oh, God, I hope you didn't turn down the offer. And they said, well, it was really strange. I know what you said about we can't go to trial and can't argue the facts. And they came out with this offer. And they asked us in the offer if we would sign below and waive our right to a probable cause hearing. Now, ordinarily with that hearing, see, all this was being done in the lower muni court because they always take you in to a municipal court on a felony charge, to a court that has no jurisdiction over felonies, to do your original arraignment. And so here is the lowest court in the land. It's lower than the settlement of Zion in the core of the earth in Matrix 2. It's that low. And this is the court that you've got to enter the pleading in to grant the subject matter jurisdiction and equity so that they can take you up to the felony court to proceed. They've got to get you to volunteer. And the offer they made them is, would you waive the probable cause hearing and just stand mute to a pleading so that we can enter a not guilty plea, waive the hearing, and send you up to the general jurisdiction court. Now, if you do this, you won't have to come in next week. Oh, well, I'm greatly relieved on that. I can keep that date free in jail now, and I can just play checkers with the rest of the people. So, yeah, I'm just dying to waive that hearing and accept your offer and stand mute at the pleading so that we can go up to the upper court. Now, out of the three people that were in there, I have been talking to the guy who's the public notary because he's not in jail. He's out on bond. And I go, anytime they offer you anything, I don't care if they offer you castration, take it. Because it's a fiction and they won't do it anyway. Just trust me, take it. Otherwise, you're in dishonor. Well, I don't know about the castration bit. I said, it's a fiction. Don't dispute it. So, rubber knife. One of those star laser swords that don't exist yet. So it's all fiction. It's all an illusion, those laser swords. They're not real. Okay, so here is the three people, the two patriots, the A group that's in dishonor, which is why they're there. And here's the public notary, and the public notary is going, he calls me up after the hearing. I go, how'd the hearing go? And I already told him, I said, look, if nothing seems to be working, don't get upset. That's normal. That'll be perfect. If it doesn't look like anything you're doing is working, just don't get upset. It's perfect. So he's on the phone and he's going, oh, I don't know. I had to sign this document today. Did I screw up? I'm already laughing. I said, well, what was it? He said, well, it's his offer that I was going to just stand mute and they were going to enter a plea for me. I said, look, anything can be corrected in 72 hours. Don't worry about it. You did perfect. Now, he is the only one of the three that accepted it. Everybody else is in a dishonor. And I'm going, oh, this is perfect. This is the guy who knows nothing. He's not the patriot. He just got caught up in patriot stuff, and when the patriot thing appeared to go wrong, he's going, I don't want to deal with this patriot stuff. It doesn't work. I'm going, what the hell do you mean it doesn't work? If it didn't work, why are they so upset that they've been in 2 cases to try to undo what was done if it ain't working? I said, your problem is not you, not what you did, not the process. My buddies weren't consistent in the process. It's denial of equal protection and due process that they're in there on, not the administrative proceedings. Well, this guy is actually smart enough. He's starting to get this. And he's starting to like this. And I said to him, I said, look what these lunatics are doing. I said, first of all, you're in the lowest court in the world. It's underneath the city of Zion. It has no authority. That court you've stymied. They don't know what to do with you. So they're saying, would it be okay with you if we don't have you with us no more because we don't like you and don't know what to do with you, and you're getting all our lawyers and all our judges in trouble, and would it just be okay if we send you up to the real court? Is that okay with you? What part of this process isn't working? They don't know what to do with him unless they get an agreement. Okay, let's go to the real court and then we'll deal with those people up there. Right? Now, he's going up to the real court. What's happening to his 2 buddies? They're in dishonor. They're not out of jail. Their bonds haven't been lowered. They're in dishonor because, see, one of those 2 people has the same paperwork in that the public notary does. The other party doesn't have that paperwork in. He put in an affidavit of truth and argued all the facts of why his title is superior on the UCC-1 versus anything that they may be arguing. And I'm going, don't you get it? You're not here because your UCC-1 isn't valid. You're here because you're in a dishonor to that other court. Well, he's starting to get that now. Just starting to get that. So the paperwork that went into the first court was the same for half of Party A and our public notary. Well, after the hearing where the half of Party A that did this paperwork like he did, this half of Party A was walking out of court, and the daughter of this Party A was in the proceedings looking at what was going on, and the prosecutor came by the daughter of that half of Party A that's got this paperwork in. And the prosecutor said to the daughter, who was kind of hyper, we're not after your parent. We're after this other party. And we want your parent to take a forensic test. Mental competency. Now, wait a minute. Now, didn't the paperwork for both the public notary and this other party basically say, we accept everything, we're not going to argue the facts, we want settlement and closure? What did the prosecutors say to that party's daughter? We don't want your parent. Oh, really? Gee, I wonder why that is now. What do you mean this process isn't working? Now, that doesn't mean that this party won't or can't screw up. Who already went into his dishonor by saying, hello, wait, I'm not going to sign that document. So I talked to that party on the phone today, and I said, why aren't you signing that document? It's only an illusion and a fiction. We'll take care of it. You're in a dishonor. Take the castration. It's good for you. You know? So the problem we're seeing here is that the patriots don't understand the weapons they're using and what's going on here. They think it's good enough for them but not for anyone else. They only catch half of the picture. The concept is you change these courts of equity into law. Now, none of this paperwork got filed in that lower court on the public side, but what did the lower court do? Bounced them the heck out of there. Now, in another week and a half, they're going up to this other court. What do they got to do? Redo everything. We're in a brand new court. You got to put that judge under notice of what you're doing. See, they start out in illusion. We got bounced out of illusion, so now we're in the second inning. We beat the snot out of them in the first inning. Now we're going to the second inning. Can't give up the game yet. You just proceed in the procedure. The idea isn't to knock the snot out of them. It's to demonstrate that you're honorable. Remember what it is? We're playing these theft games against you to determine whether it's all about the wealth or whether it's all about defining who you are. The attorneys and the judges and the courts are playing this scam knowing full well it doesn't comply with the law. It's not real. It's a total illusion. Why are they doing it? Well, many of the patriots will say they just want to make a revenue off of us. Maybe what they're trying to do is act as agents for our Father, to define us, to see who we are, to see what motivates us, to see whether we're honorable children or not. Instead of looking at the glass being half empty, maybe we ought to look at it being half full. We're past time tonight. I appreciate your sitting here listening. If it's God's will, we'll be back next week.